Okay, in our next video vignette with regard to the Kentucky Realtors statewide contract, we're going to talk about the price and terms section of the contract going to offer. And I want you to keep in mind that the primary goal of this section was to increase the transparency and the truthfulness of any offer received to the seller from the buyer. So we're going to start first at line 39, and that deals with the purchase price, which is, in days gone by, the most important thing that a seller would look at. So you want to buy a piece of property, the first thing the owner of the property would say is, how much are you offering? And that's really what line 39 is. It is just strictly how much is the initial offer. So let's, in this circumstance, say the initial offer was $400,000. Well, the next question that would often come up in a transaction would be, well, all right, if I'm going to take my property off the market, I want to know you're serious. How much money are you willing to put out to show that you're serious? Now, this was typically defined as a good faith deposit, or more recently, the earnest money deposit, meaning how earnest are you in your offer? The higher that number may be, the more earnest you are determined to be. And supposedly, again, the higher that number may be, the more encouraged the seller may be to accept that offer. Let me give you an example. I'm offering $400,000 and I'm offering to put $40,000 down. The next person comes in and says, I'm willing to offer $405,000, but I'm only willing to put $500 down. Well, there's a significant difference there. And if the seller's main goal is to get to the closing, he may be more likely to take my offer, even though it's less than the other party's offer, because my offer shows an amount of earnestness that the other offer doesn't show. If I'm putting up $40,000, $50,000 right up front, that should give him should give the seller a sense of well-being that the transaction is actually going to close, as opposed to offering $500 on a $400,000 purchase. So lines 39 and 40, and again we're looking at those numeric numbers on the side, deal with paragraph 2, and they deal with the purchase price and the earnest money. Now, the next section, which begins on line 41, is paragraph 3. So we now know the purchase price. We now know the earnest money deposit. Now what we're going to do is we're going to talk about how that purchase price that the buyer is offering, how that's going to be created, meaning where's the money coming from? Does he have it all in his pocket? Does he need to get it from another source? And if so, is that source something that I need to be worried about as a seller? So the first thing you're going to see is that the purchase price shall be paid as follows. So you're looking at line 2. So let's take that $400,000. And line 42 deals with cash, meaning how much cash the buyer is going to bring to the transaction. And if on line 42 you notice there is the ability to put down a set amount, that is the first bar, or a percentage, and that is the second bar. Now, my personal opinion is that you should put an amount and not a percentage, at least initially, because since there may be an offer and a counteroffer going back and forth, if you put a percentage, everybody's got to remember that, hey, that number is going up. Meaning the buyer's going to have to keep bringing more and more money to the table. Whereas if you put an amount, it's only if the seller's coming back and asking for more will the buyer necessarily have to increase that cash amount. He can bring more cash, or he or she can bring more cash to the transaction. They're just not required to. Now, here's another important component about cash, though, line 42. If I say as an offer that I have $100,000 in cash, that doesn't mean that I have $100,000 worth of gold, and that assuming the market's okay, when I go to sell that gold, I should have $100,000. And that doesn't mean that I have $100,000 in an IRA that when I'm ready to liquidate it will become $100,000 in cash. Cash is cash. That means that I can write a check for it, or that I can go and get it out of the bank, or that I literally have it stuffed in my mattress. It is liquidity. It is cash. So if you say you have cash and you are going to use that cash toward the transaction, and in fact that cash is coming from another source, meaning that money, meaning it's not coming from your mattress and not coming from your pocket or your bank account, let's say it's coming from a rich uncle, then you're committing fraud, because cash means your money. And if you are getting your money from another source and you are not telling me that you are doing that, you are attempting to make your offer look, as we talked about earlier, more earnest. And that is a material fact. And a material fact that you lie about can give rise to a fraud claim, which can also give rise to punitive damages and potentially losing your license and losing your realtor membership, any number of things. So make sure that if you are the buyer, you're talking to a buyer, that you really explain to the buyer that cash means liquid cash. And if that buyer says to you, well, I'm actually getting it from an uncle, but he's good for it, don't be confused. Once he tells you that he doesn't have that cash, you should not be writing that in as cash on the offer. So cash means cash. It means liquidity. And it doesn't mean you're getting it from another source or you're selling your Cabbage Patch collection or anything like that. So then we go to line 43. Now, line 43 talks about other sources that you may be getting the money from. So let's say that you have a $400,000 offer, you've got $100,000 in cash, and then you're going to get another $100,000 in an equity line for a property that you own. Well, that would bring your total that you're getting as cash and the equity line of $200,000 total, which means you would only need to finance the rest, which would be $200,000, and that could make your offer very attractive. On that same line is a gift, and on that same line is other, meaning some other source of income. Now, source of funds. Now, let's talk about line 43, because an equity line doesn't mean you're going to go get one. It means you have one and that money is available. That gift doesn't mean that you're going to be standing out on the street hoping somebody hands you $100,000. That means you've got that gift already, meaning somebody has already committed to giving you that. Now, what's also important is if you're the listing agent and you see gift checked there, your first response should be, okay, where's that gift coming from? And why don't we go ahead and have that person that's giving the gift, why don't we have them sign the contract too? Or let's get a lawyer and have them put together a guarantee that says that person will put that money up no matter what. Because otherwise you have a hole in the contract that can create big problems down the line. On line 44, it says where the remaining amount of financing is coming from. So you're going to check if it's conventional loan, an FHA loan, a VA loan, a fixed rate loan, adjustable rate, or other. It's also going to talk about how many years you're going to be amortizing this loan over, 30-year, 15-year, what have you. And also what interest rate is not to exceed. Now, don't put in here something like TBD, to be determined, or just slap on pre-approved or what have you. Because remember, what you have here is a contingency. Now, in order for you to be released from the contingency, you must not be able to qualify for that loan. So if you leave off the amount of years, for example, or you leave off the percentage rate, I'm pretty sure I can find you someone that'll loan you that money. So let's imagine you need $200,000 and your client was hoping to get it at 3%. They can't. And so they want to get out. But they haven't put a percentage there. They haven't put an interest rate. Well, I could go to someone and say, hey, I got this guy over here. He'll give it to you for 20% interest. Well, nobody would want that deal, but because you failed to insert that, there is an argument they've got to take it in order to utilize that contingency. So make sure that all of these areas are filled out. Now, for an adjustable rate, the adjustments are limited to the following. Also, if financing other than an equity line is involved, this contract is contingent upon the buyer qualifying for a loan with the above financing terms and conditions or better. That's what line 47 says. So again, when we're talking about that equity line, what we mean is you can't make this and then in order to get out of it say, well, I didn't qualify for the equity line I referenced on line 43. No, you were already supposed to have that available. So there should be no qualification and there is no contingency related to that equity line. So for example, you get the equity line, you say you have $100,000 in equity line, or your client does, and when they come to close, they've actually spent $75,000 of it on their new car. And then they say, well, that only left me 25, so I can't qualify for my loan. Too bad. They are not out under a contingency. They have actually breached the contract. Now, the next line is line 49. It says, if the buyer has acted in good faith and does not qualify for the loan, buyer may void the contract and receive earnest money deposit and refund. Let's talk about that, because that language, if the buyer has acted good faith, is important. Kentucky has a concept that says that there is an implied covenant of good faith within all contracts, whether you say it or not. That means that you are going to work toward, as a participant or a party, you are going to work toward trying to get a contract done. So you can't purposely not answer your loan officer in the hopes that the contract will go bad because there's this implied covenant of good faith. But with this contract, we're going even beyond that. We're saying we know there's an implied covenant, but now we're saying that you have contractually agreed to act in good faith. So it's not just this kind of amorphous implied covenant. Now you have actually contractually agreed to do so. So your failure to respond to your loan officer, or your client's failure to respond to their loan officer, or failure to provide documentation that they need, will not allow them to use the contingency related to financing to get out of the contract. They must attempt in all reasonableness to complete this contract. If they don't, that contingency won't be available to them. Now, the next line is on line 50. It says that the acquisition by buyer of earnest money deposit, cash, equity line, gift, and or other source of funds noted on lines 40, 42, and 43 above is not a contingency. Okay, now what does that mean? Again, it goes back to what I said earlier. Your ability to get that cash, your ability to get that equity line, gift, or whatever other source of fund you reference there cannot trigger the contingency. So if the loan officer says, well, they can't get this loan because they can't utilize their equity line, then they're in breach of contract. They're not getting out of this as a result of the contingency. So line 42 and 43, they better have in hand when they make the offer. Also, what's important here is it says that the buyer must apply to said loan within blank number of days. Now, people say, well, but Jason, what if that doesn't happen? Well, if it doesn't happen, arguably, the buyer is in breach. Now, what happens when the buyer is in breach? Well, for one, there is an argument, and I'm not telling you to do this, but there is an argument if you're the listing agent that you can talk to your seller, tell them to go see a lawyer, but that lawyer may very well tell them if they're in breach because they haven't done something in the contract, that excuses the seller's performance, which means the seller could go sell it to somebody else. On top of that, because the listing agent has had to sell it a second time, they could go and pursue the buyer for their portion of the commission and also recover the commission on the new sale. So people that tell their buyers, oh, just don't worry about it, it's not that big a deal, be very careful, because if the seller gets wind of that this is not being followed or not being done, they could come after your client for extensive damages and be excused from performance potentially. So make sure your client, if you're representing the buyer, follows this provision and applies for said loan within a time frame. And in the next line, it very much is clear about that. It says failure to apply for the loan shall constitute a breach of this contract, in which case seller may either A, grant a written extension of time, B, void the contract and retain the earnest money deposit as liquidated damages, or C, pursue a claim for damages as a result of the breach. They have to go apply for this loan right away. Don't let them just think that they can go and do it later. They have to follow the contract. The next line on line 53, any change in financing terms or lender must not adversely affect the seller's proceed or the closing date. Any change in the financing terms or lender must not adversely affect the seller's proceeds or the closing date. So what are we saying? We are saying that you can't say, well, I went with a different lender and the result of this is going to be a slight reduction in the seller's proceeds. Nope, can't do that. Or I went with some different financing terms and a different lender, and now we got to close 20 days later. Nope, you can't do that. Again, the buyer would be in breach under those circumstances. If you need to go to a second lender because of a problem that you've done or a problem that's come up, then what needs to happen is that the selling agent needs to contact the listing agent to tell them, we've got an issue. We do want to continue. Can we sign an addendum that allows him to go to a different lender? Or can we sign an addendum that allows him to get additional time? Or can we sign an addendum that allows him to change the terms? Whatever it may be, you need to talk to the seller because failure to do so could possibly result in a breach of contract. And then the last line says, seller shall be informed of the progress of the loan, including any change to the above financing terms or selected lender. So the buyer has an obligation to let seller know how the loan is going, in particular as it relates to financing terms or which lender they're using. Failure to do this will be a breach of contract. Lying about what they're doing could be fraud. And if you as the agent participate in that lie, you could also be part of a fraud claim, which would be very bad because that's not covered by your E&O insurance, and it could result eventually in the termination or suspension of your license and or membership with the KYR or license with the Kentucky, what have you. And then in line 56, we're going to put down the lender contact information. Now, this doesn't mean necessarily that the lender has to communicate with the seller. They may say they're not going to. But it does lock in the buyer to identify who their lender is going to be from the very beginning. So if there's a subsequent change, the seller may recognize that there has been a breach of contract. Let's go to line 60. It says, should this transaction be financed by a VA loan, seller agrees to pay certain fees not to exceed blank amount. Talk to your seller about that. Make sure that you put an amount in there. Don't just leave it blank, because if you leave it blank, there's no control. Which buyer, because the VA guidelines cannot pay. The next line, except for earnest money deposit, all monies necessary to close shall be tendered at closing by certified funds. Okay, so this does allow for some transfer of the earnest money deposit through various different methods, but everything else must take place through certified funds, and you want to make sure that all parties are aware of that. The last one here is really important because I know in some areas of our state there is some dispute over closing costs and what can be done and reduced and what have you. This contract says it's going to be determined by local custom. So buyer and seller shall pay their respective closing costs consistent with local custom. That's not a perfect solution. But that's one that, in light of all the varying circumstances, that we believe is the best. If you have questions about it, clarify it in the beginning, up front. That way you're avoiding any conflict down the road. Now, if you recall in the beginning of this, I said there were some key goals in this contract or in this section. And one of those goals was transparency behind the buyer's offer, meaning not just what the buyer is offering for the property, but how the buyer is going to procure that money in order to complete that offer. Now, there is another component of that, and that is truthfulness. One of the things that we really want to make sure of is that if a buyer is locking up a seller and a property, that the buyer is truthful in what they say. And that's where lines 63 and 67 come in, because this might be unusual for your contract, your local contract, or differ from your local contract. It says that buyers represents to seller, the listing company, the selling company, and their respective sale associates, the Kentucky Realtors, participants in the local MLS, that the information provided above by the buyer related to any source of funds and/or buyer's ability to pay cash is true, accurate, and complete to the best of their knowledge. But it goes on, and it says the buyer shall indemnify and hold harmless all the foregoing parties from any liabilities, damages, costs, fees, and expenses, including attorney's fees, resulting from any fraudulent information provided herein or in any other writing provided by the buyer. So essentially, if the buyer lies about how they're getting their money or the fact that they actually have that money, they will not only be subject to a breach of contract claim, they will also be subject to a fraud claim. And finally, which can include punitive damages, but finally, they may also have to pay the attorney's fees and the various commissions of the parties involved. So lying in this financing portion, this transparency to the seller portion, could result in damages that far exceed the amounts involved in the case or in the transaction. So you should be very careful of making sure to emphasize, when you are the selling agent, to emphasize to your buyer that they need to be absolutely truthful and not to stretch the truth when completing this section. And the sections that I'm referring to are under price and terms, beginning on line 38 and taking us all the way down to line 67, and include paragraphs 2 and 3. Our next portion, or our next video vignette, will begin with the earnest money deposit. Hopefully this has helped you out and will assist you in the use of the Kentucky REALTORS statewide contract.